Minister and leader of government business wishes to make a statement on behalf of the government. Please proceed, Honorable.
Thank you very much, Mr. Speaker, honorable members. I rise to make a statement coming from the office of the President. Walter Rodney, 33rd death anniversary. The administration has never stopped reflecting on the assassination of Dr. Walter Rodney on June 30, 1980. The administration has noted the unsuccessful, inconclusive results of attempts to inquire into his killing. The family has persisted in its efforts to have the killing inquired into conclusively. The President, in the context of those realities, and particularly the urging of his family led by his wife, has decided to constitute an international commission of inquiry into the killing. Thank you, Mr. Speaker.
Thank you, Honorable Prime Minister.
Personal explanations. Request for leave to move the adjournment of the National Assembly on definite matters of urgent public importance. Motion to listen to the business or sittings of the National Assembly and moved by Minister. Introduction of bills.
Honorable Prime Minister, the Minister of Parliamentary Affairs.
Mr. Speaker, honorable members, I rise to lay before this House the Hydroelectric Power Amendment Bill 2013, Bill number 50 of 2013, a bill intituled an act to amend the Hydroelectric Power Act, and I beg that it be read for the first time.
Mr. Clerk, let the bill be read for the first time, please.
Hydroelectric Power Amendment Bill 2013, Bill number 15 of 2013. Government, public business, government's business.
Thank you. Honorable members, we will proceed now with the second reading of the Evidence Amendment Bill 2013, Bill number 7 of 2013, which was first published on the 14th of February 2013, and so I invite the Honorable Minister of Home Affairs to start the second reading of this bill.
Thank you, Mr. Speaker. Mr. Speaker, I'm pleased to proceed with this bill, which I believe, Mr. Speaker, is quite innocuous, not to generate any controversy with respect to its intention. The intention of the bill, Mr. Speaker, is basically to expand the documents to which Section 43 of the Evidence Act applies, and to include in the definition of analyst, an analyst of the Guyana Police Force or of the jury qualified person, without, of course, taking away the right of the accused or the court, for that matter, to test the reliability of the report or the certificate presented by the analyst. That is basically the fundamental thrust of the intention of this bill, Mr. Speaker. The intention further is to make admissible in evidence without the testimony of the analyst to prepare the report. And I must say with one caveat that unless the analyst is required to give evidence pursuant to the instructions received from the court on application by any party in the court proceeding. The report of this duly qualified person or persons who have analyzed a certain matter and stated the results of the analysis. Mr. Speaker, currently the legislative provision under Section 43 of the Evidence Act allow certain specific reports compiled by experts to be tendered and used in court without the need for the analyst to attend the court and to give evidence. These include, Mr. Speaker, post-mortem reports prepared by the pathologist. Currently we have 2 pathologists in the country. And secondly, medical certificate prepared by a registered medical practitioner after examination of a virtual population. Mr. Speaker, in addition to these 2 reports mentioned in Section 43(4) of the Evidence Act, the report of the analyst who runs the test on suspected narcotics is also admissible in evidence without the need for that analyst to attend court to give his evidence, unless otherwise directed to do so. And reference to this could be found, Mr. Speaker, in Section 18 of the Narcotic Drugs and Psychotropic Substances Control Act. It deals with the question of the analyst. Mr. Speaker, in practice, after the analyst of the narcotic conducts a test on the suspected narcotic, he fills out what is called an analyst form with his findings, signs the same, hands it over to the police. And the police rank who would be appearing in court. That rank collects that evidence and is tendered through him rather than the analyst himself or herself presenting it. We have the same, Mr. Speaker, in respect to the Evidence and Motor Vehicle and Road Traffic Amendment Act, which has to do with driving under the influence of alcohol. Where, in this case, another analyst would do the necessary analysis and prepare the certificate signed by a registered medical practitioner. And the same would apply where the police would present that certificate or that registered medical certificate. Mr. Speaker, as is normal in what the lawyers would describe as evidential practice, the reports of the analysts are admitted in evidence after certain elements are established before the court. And the contents of the report are used as evidence in the matter, even though the person who made the report is not present attending court to give that evidence. Mr. Speaker, the question of post-mortem reports. Currently, the only time the pathologist will attend court is if there is a request by a party to the proceeding or the court itself for the pathologist to attend the court to explain something to the court. Mr. Speaker, we in the National Commission for Law and Order had several lengthy discussions on the question of initiatives that we can take to make amendments to the Evidence Act. Because it is the mandate of the National Commission for Law and Order examine the laws and to make recommendations to Cabinet in respect to such matters. The Legislative Subcommittee of the National Commission for Law and Order, having examined this particular matter, found it appropriate to approach Cabinet to make certain amendments to the Evidence Act in accordance with what is reflected in this bill. And the reform that we are proposing in the bill is to request that certain statutory provisions be enacted in relation to the admission of evidence of the reports of the analysis of the following fingerprints, firearms and ammunition, poisonous and noxious substances, local and foreign currencies, human blood, bones and tissues, fuel and fuel-based substances. Mr. Speaker, it is noteworthy to take into consideration that we're moving in this direction because at the same time, the forensic laboratory has declaring completion, which will bring to new heights the question of analysis that present and the presentation of evidence in court would require the information of the court when evidence of this type is presented in order to legitimize, so to speak, the legal aspects of these matters. And I believe, Mr. Speaker, that passage of this bill will go far way in assisting from a strategic point of view the forensic laboratory when it becomes fully commissioned. So, advance its strategic plan and the terms of reference to which it has mandated. Mr. Speaker, it is noted that there is currently no legislation providing specifically for the admission of the reports of these analysts into evidence without the testimony of the analysts who prepared the report, which can be, as expected, very time-consuming. Accordingly, Mr. Speaker, Section 43(4) of the Evidence Act has been amended to include the above-listed report from these sections, in addition to postmortem reports and the report from the GB registered medical practitioner. So that in addition to the reports from the pathologist and the medical practitioner, we are amending the Act to include reports being presented as evidence from those areas that I earlier mentioned. Mr. Speaker, Section 43(5) is also amended to include an analyst of the Guyana Police Force or any other qualified person that the minister may by order prescribe. Since some of the substances are analyzed by agencies which do not fall under the remit of the Ministry of Home Affairs, for example, poisonous and noxious substances, local and foreign currency, fuel and fuel-based substances. These fall under the agencies of other government, under the aegis of other government departments. So, Mr. Speaker, I believe that the bill that we have before us is, as I said, quite innocuous and forward-looking and aims to enhance the criminal justice system, will put the intended forensic laboratory in good stead and will raise to new heights, Mr. Speaker, the quest to ensure that there is justice based on scientific material and reports in order for persons who feel aggrieved to feel some measure of satisfaction and justice. Thank you.
Thank you, Honourable Member. Attorney General of Mr. Nandla.
Thank you very much, Mr. Speaker. Mr. Speaker, in 1972, our Evidence Act was amended. I have no doubt to meet the circumstances and the exigencies prevailing at the time. At that time, it was felt that those circumstances necessitated a change of the then Evidence Act to include, with some degree of smoothness and ease, some aspects of evidence in a court of law. Then the amendment sought to introduce into evidence medical certificates from a registered medical practitioner, obviously important in litigation, to prove the injury which is being claimed was sustained in any legal proceedings. And that was the major thrust. It also included post-mortem reports to be admitted into evidence to establish, obviously, the death of a deceased person when such a death would have become an issue of moment in any given legal proceedings. It also permitted the admission into evidence certificates which were to be submitted by analysts attached to a department of government, which certificates would have tended to establish or would have supported the establishment of some scientific fact which would have become of some evidential value in the determination of any legal dispute. Those were the changes in 1972 which were made to the Evidence Act, as I said, to meet the demands, the circumstances, and the needs at the time. Well, sir, from 1972 to now, the world has changed significantly. Our country has changed, litigation has changed, but most importantly, science and technology has made tremendous advances. And it is now a recognizable notion in lawmaking that the law must remain as dynamic as it possibly can and change to meet circumstances that develop in a society, lest the law becomes outmoded and out of sync with the changes that are taking place in a society. Therefore, we have a duty in Guyana to ensure that we constantly and we vigilantly review our legislative landscape to bring it up to date with the changes which are taking place in our society, in our constant quest to ensure that our law as a social institution and as part of the legal architecture of our country is kept abreast with the development, the social realities, the scientific realities of today's world. And that is the principle which has inspired the presentation of this bill to the National Assembly. It seeks to substitute a provision which we inserted in the law in 1972 to, as I said, meet today's reality. As I said, the 1972 law which we passed in this House, which forms part of Section 43 of our Evidence Act, subsection 4, this bill seeks to remove that and to substitute in its stead a new subsection 4 and to inject into the Evidence Act a wider bracket of reports which can now be admissible in evidence. Today, sir, if one visits the magistrate's court, and what I'm speaking about, sir, would be very readily discernible by legal practitioners, and Your Honor will be very well aware of it. Today, in the magistrate's court, for example, a medical certificate can be admitted without the need for that medical practitioner to present himself to testify in relation to that certificate. Obviously, the court always has a residuary discretion and power to summon that medical practitioner if the court feels, or a party who has an interest in the proceedings feel that they need to cross-examine, or the court needs to conduct some other inquisition other than the content of the medical certificate in its quest to arrive at a just decision. But it makes it extremely expedient for a certificate to be made admissible in lieu of oral testimony. And what this bill seeks to do is to expand way beyond the category of medical practitioners to include certificates signed by a fingerprint expert, a firearm or ammunition expert, which in this instance would be the ballistic expert, a poisonous and noxious substance expert, a local or foreign currency expert, a bone and tissue expert, and those who are trained in the detection of fuel, in the examination or analysis of fuel and fuel-related substance. In terms of fuel, sir, as Your Honor is aware, fuel smuggling is an offense, and being in possession of fuel that does not contain a marker of a required proportion is an offense in Guyana, and we have prosecutions all across the country in which persons have been charged in relation to these types. And many of these services are now performed by an agency which technically may not fall under a department of government as it would have some years ago. The Guyana Energy Agency, while it falls under the office of the Prime Minister, it really is a statutory body corporate governed and being administered by a board of which there is a chairman, and the agency is run by a CEO, statutorily defined and delineated with responsibilities. And the role of the minister is not an unregulated one, but one which is regulated by a statute creating the agency. So, Mr. Speaker, this is a bill that, in my view, as small as it is, it has great practical value, particularly to our legal system, and more specifically because it will have the impact of bringing speed and dispatch and expediency to the system. And also, it allows for professionals who would have had to sacrifice a lot of their time to be in court to, because now your presence may no longer be as necessary as it would have been prior to this enactment. They can now spend a lot of their time actually concentrating on their work. And of course, we speak here of a whole variety of professional people attached to the various agencies of government and state. So therefore, sir, I have absolutely no hesitation in lending my full and absolute support to this bill. Thank you very much.
Thank you, Honorable Attorney General. Any other speaker? If there is no speaker, I invite the Honorable Minister of Home Affairs to reply.
Thank you, Speaker. Speaker, I believe that apart from what I said, the Attorney General has captured quite succinctly the intention of this bill. There's one word I believe, Mr. Speaker, that encapsulates what I said, or what the Attorney General said. And that is that this is a progressive piece of legislation. Irrespective of how you call it or twist it, whichever perspective they look at it from, it has to be indeed a progressive piece of legislation. It is moving the process forward. It is forward looking. And more than that, Mr. Speaker, it addresses a concern which I believe that quite a large number of Guyanese would be heard talking about from time to time, or calling for from time to time. People in this country are now quite habitual callers for justice. And this call for justice is not only political justice, social justice, economic justice. This is justice of a very wide board. And so I believe from that perspective, from those two perspectives, one, the legislation being progressive, and two, democratic in nature, the bill, Mr. Speaker, should be supported. There are two basic amendments, Mr. Speaker, widening the scope of the nature of the analysts, and two, widening the scope of the institution, which analysis would be or could be presented in the court. That by those two amendments, by their very nature, speaks to the progressive and the democratic nature of the intent and the trust of the individual. I wish, Mr. Speaker, therefore, with this in mind, ask that the bill be read third time, and that the bill be considered for, that the bill be considered a second time, and that it be considered for reading a second.
Grateful, Honourable Minister. Honourable members, the question I will now put, and that is that the bill as requested be now read for the second time. Those in favor say aye. Aye. Those against say no.
No.
And division is sought.
Do we have the division bill, please?
Clerk advises that 32 members voted against the motion for the second reading and 26 members voted. The motion is not carried. Thank you. The bill will now be read a second time. 2013, Bill number 8 of 2013, first published on the 14th of February 2013. The bill is to be presented by the Honourable Minister of Home Affairs. I invite you now, Honourable Minister, to proceed.
Thank you, Mr. Speaker. Struggle continues.
I move that continue on.
Mr. Speaker, in anticipation of opposition adopting a similar posture as they did in the previous bill, I have no reason to doubt that. I was 10 before the gate and the benefit. Mr. Speaker, this bill that we have before us, I want to use the tone, the amendment to the Evidence Act, in the context of changes taking place within our economic and social environment. And this bill has to be seen in a similar light. Whereas the first bill, Mr. Speaker, is related to the criminal justice system, and in fact seeking to bring greater acceleration to matters before the court, the way that was described by the Attorney General. I believe that this one is also similarly destined. The peculiarity with this bill, however, Mr. Speaker, is that it seeks, in the current context, to address the question of vehicles used in the commission of a crime. Mr. Speaker, if I'm to leave this Parliament, no. And go to any location where people would usually congregate, be it a market, a shopping plaza, a street corner, a social event. And I seek to solicit their views on the question of motor vehicles being used in the commission of a crime. I do not think I would find it rare if they were to, if the majority of such persons question will be unanimous in their view that in today's society, be it Guyana or any other developed or industrialized country, motor vehicles are currently being used to commission crime. Drive-by shooting, execution, robbery, hit and run. So many of them taking place because the use of a vehicle, which modern criminology are now describing as a weapon to execute or to commission a crime.
It started to.
Mr. Speaker, this bill seeks to capture the challenge of vehicles being used in the commission of a crime and to block all possible loopholes in the law that are used by persons to prevent those who use a vehicle in the commission of a crime from facing the full brunt of the law.
It started at 32.
Mr. Speaker, to our scope, the bill seeks to expand the definition of ownership. Because many times when a person is found or a vehicle is found, there are 1,001 questions that are raised about who is the owner of this vehicle. And many times cases collapse as a result of this matter not being clear. So, Mr. Speaker, definition of owner for the purposes of the Motor Vehicle and Road Traffic Act to include a person who is in possession of a motor vehicle under sales agreement, a power of attorney, or a bill of sale. These are the usual transactions under which or through which persons become owners of it. It would therefore consider necessary, Mr. Speaker, to include those persons who, although they are not registered owners of the vehicle and may be in possession of a motor vehicle, even enjoy the benefits of the ownership, but are not subject to the obligations of the owner. This bill seeks to capture such persons in this bill. Clause 3, Mr. Speaker, facilitates through amendment to section 10(1) of the Motor Vehicle and Road Traffic Act. I should point out, Mr. Speaker, before continuing, that this bill is what could be described as a composite bill. It's composite in the sense that it seeks to address a range of independent matters which necessitate amendments of the Principal Act. So the first question we are seeking to address is the question of ownership. The second question, Mr. Speaker, to be found in clause 3 of the Motor Vehicles and Road Traffic Amendment Bill, which facilitates through the amendment to section 10(1) of the Motor Vehicles and Road Traffic Act, the tightening up of the registration of motor vehicles. For example, Mr. Speaker, that's to say, when there's a change of ownership of the motor vehicle, which necessitates a change in the registered owner, otherwise than by death. The proposed amendments to this section, Mr. Speaker, seeks to detail the procedure that must be followed after both the registered owner and the person in whose possession the motor vehicle has passed apply in writing, providing that they relevant details in respect of the change of possession to the licensing officer within 7 days, within a 7-day period subsequent to the change of possession. So what we're seeking to do here, Mr. Speaker, is to tighten up the procedure for the change of ownership from one person to the other. Mr. Speaker, these amendments require that the vehicle must be brought to the licensing officer and the registered owner and the newly intended owner must be present when the licensing officer enters into the register and the certificate of registration, the name and address of the person into whose possession the vehicle has passed. The effect of which, Mr. Speaker, is that the latter is deemed the registered owner of the motor vehicle. Mr. Speaker, the proposed section 10(1)(c) caters for instances where a company is involved, requiring that a letter of authorization signed by a director of the company, authorizing the representative to act on behalf of the company to be produced to the licensing officer. This may seem to be rather tedious, Mr. Speaker, in nature, but unless we do these, what could be described as tedious things, person will continue to escape the full brunt of the law. Mr. Speaker, provision was made for the insertion of a section 10(4), whereby if the registration is not effective as required, the person into whose possession the motor vehicle has now passed is vested with the rights, powers, and liability as if they are the registered owner of the vehicle. Mr. Speaker, all of this has to be completed within 7 years after the change of possession of the vehicle. And were this not to happen, a fine of $150,000 and to the imprisonment of 3 months would be dependent that the default will happen. There's another composite aspect to this bill, Mr. Speaker, which has to do with the demerits point system. Mr. Speaker, the traffic ticket system under the Summary Jurisdiction Procedure Act, Chapter 102, is not accompanied by a general demerits point system as employed in other jurisdictions. And maybe recall, Mr. Speaker, I think it was the previous Parliament, 2008, when the Evidence and Motor Vehicles and Road Traffic Amendment Act, when we sought to amend that act, Section 103(1) of that act, to make provision by inserting a paragraph which would read, the procedure for the assignment of points of conviction of certain offences known as the demerit point system. Mr. Speaker, upon enactment of that act, that is 1041A of the Motor Vehicle Road Traffic Act, that would have empowered the Minister of Home Affairs, subject to negative resolution. Sorry, not revolution, positive resolution. To make regulation for, quote, assignment of points on conviction of certain offences known as the demerit point system. In other words, if a person will have committed so many traffic offences, the demerit point system will have applied on the commitment of every offense, of each offense. So that by the time the third and more serious traffic offense would have been committed, the merit point system application would have denied that person a driver's license and prohibition from driving a vehicle on the roads of this jurisdiction. Mr. Speaker, it was nevertheless, however, discovered that in attempting to draft legislation to establish a comprehensive demerit point system, that we were confronted with certain limitations. And that any regulations which included a provision that the person be disqualified by the licensing authority from holding or obtaining a driver's license after the accumulation of certain demerit points would clearly be out of section 104, and therefore the regulation making power of the Minister of Home Affairs. Therefore, Mr. Speaker, we found that for the penalties visited by the demerit point system would exceed the maximum penalty of $30,000 provided under section 104(2) of the Motor Vehicle Road Traffic Act. And that is why it is now deemed better and more effective to proceed by amending the Motor Vehicles and Road Traffic Act to provide for the demerit point system while deleting 104. So that at the end of all this, Mr. Speaker, Clause 4A of this bill seeks to establish a comprehensive regime for the administration of the demerit point system. In other words, we create new sections 33A to 33H. The introduction of these new sections, Mr. Speaker, has to be read together, or the lawyers would say, mutatis mutandis, with clause 8, which inserts a third schedule that lists the offenses captured under the demerit point system and specify the demerit point therein. Mr. Speaker, all this may appear to be rather technical, but it cannot be otherwise, lest there be room, space for misinterpretation. We've had to be as detailed as this in addressing this particular aspect. Mr. Speaker, the motor vehicle used in the commission of an offense. In this respect, Clause 6 introduces an offense under new section 108A, where a person who drives or operates a motor vehicle used in the commission of an offense, read to mean crime, for which the penalty is not less than 6 months imprisonment, or who uses the motor vehicle to facilitate the commission of such an offense, shall be liable on summary conviction to a fine of $150,000 and to imprisonment 12 months. Shall be disqualified. This is how the demerit point system will now kick in. In addition to monetary fine and imprisonment, the person will be disqualified for a period of 2 years from the date of conviction from holding or obtaining a driver's license. Finally, Mr. Speaker, on the question of failure to report lost or stolen motor vehicle, because there are some persons who rent their vehicle, and then all of a sudden they claim that it was lost and it was stolen, or a vehicle may have been legitimately stolen or lost. Some reason or the other. creation of an offense under a new section 109A, where, Mr. Speaker, if the registered owner of a motor vehicle has been lost or stolen, if that person fails to report to police station within 7 days of the loss or theft, he or she shall be liable on summary conviction of a fine of $40,000. So you're obligated now under the law to report within 7 days the theft or the loss of this vehicle. This is key. Because at the end of the day, it is not unusual that vehicles used in the commission of a crime could find itself caught up in these legal conundrums, thus allowing either the vehicle to return to whoever claims to be the owner, or the part owner, or the lessee, or the renter, lessee or the renter, to get out from the crime. So, Mr. Speaker, I believe that this bill calls on this House for it to be supported. Those who stand on the side of fight against crime, those who stand against the use of vehicles used in the commission of crime, ought not to have any difficulty whatsoever, Mr. Speaker, in supporting this bill. Thank you.
I invite the honourable member and minister to Bell to address us.
Thank you, Mr. Speaker. Mr. Speaker, honourable members, the Honourable Minister for Affairs Clement was pretty detailed and distinct in his description of the issues which he seeks to have arranged in a proper way in the motor vehicles and road traffic amendment bills to take account of the realities which now obtain with respect to the use of the motor vehicles in the commission of crime, the question of the proper registration and the procedures required here to make sure that there is a clear and transparent record of the ownership, the transport of motor vehicles in relation to being able to undertake a continuing fight against crime. Much of it these days involves the use of motor vehicles, as the Honourable Minister did say, the use of vehicles in the commission of a crime, whether they are rented out, leased out, or whether we have situations of those where people report after the commission of a crime, when there's a discovery of the involvement of the vehicle, respect of the commission of the crime, then there is a story that the vehicle was in fact stolen, and the circumstances are not sufficiently clear to the authorities as to the ownership and the use and the authorization of respect to that vehicle. The issue that I really wanted to pay some attention to, I of course support the issues with respect to the registrations, the transfers, the procedures to be adopted with respect to the transfer of the motor vehicles. This is one of the activation of the demerit system clause for the 33H. As the minister said, this outlines the regime for the activation of the demerit system. I think this has been long overdue. It is very important. We all, as users of the road, as drivers of motor vehicles, applied cumulatively if we make breaches with respect to the Motor Vehicles and Road Traffic Act. And so I think significantly we are coming into the modern age, as the minister said, another piece of progressive legislation in the form of this amendment with respect to bringing in the points demerit system. So there is the individual responsibility of the owner, the operator of the vehicle, in fact, as to what his responsibilities are, or what sanctions are applicable on the next infringement, and that the owner, the operator, in fact, should have a clear sense and a clear responsibility of trying to take every action to make sure all the time that they should avoid as much as possible taking any action which would prevent recurrences, repeat occurrences with respect to our traffic laws.